A very warm welcome to the second National Convention of Insolvency Professionals and Registered Valuers, hosted by ICSI jointly with ICSI Institute of Insolvency Professionals and ICSI Registered Valuer Organization. It is indeed a privilege to have all of you here as we gather to deliberate on the theme, Insolvency and Valuation, Navigating Challenges and Future Pathway. This esteemed event brings together leading minds from the judiciary, government, industry, and academia to share their insight on the evolving dynamics of insolvency and valuation in India. Ladies and gentlemen, thank you for being part of this convention. Also to those who have joined us today live virtually. We would also like to thank our sponsor, RRR Insolvency Service Experts LLP and Primus Insolvency Resolution and Valuation Private Limited for supporting this convention as industrial sponsors. Our esteemed dignitaries for the inaugural session has arrived, and it is my honor to invite them to the dais. Ladies and gentlemen, please join me in welcoming them with a resounding round of applause.
Prepared a long list of questions, but due to the paucity of time, we'll give you a chance to ask. We can take, I think, 2 or 3 questions. So, but your question should be very precise. It should not be very personal. It should be useful for everyone. So please go ahead, ma'am. First question.
Hi, I have a very different question with regards to IBC. So there are companies which are financial sector oriented. For them, RP is actually appointed as an administrator. They act as a role as an administrator. So my question here is only one point. In normal cases of IBC, as rightly pointed out by the panel members, that there are non-cooperation of data in terms of promoters, we don't get usually. But in terms of financial sector bodies, companies, wherein they go into IBC process, their process are very smooth. The directors are not resigning until NCLT admits the petition. So why there is a difference between in both the cases? Because in first cases, directors are usually resigning, they're not cooperating, and the data usually doesn't come up. So if you can just comment on financial sector body IBC process would be a great per se point.
I want to add something. Sir, please, sir.
Yes. As far as your question is concerned about resignation, I do not know from where you brought this resignation thing in picture. Just hold on. It is only the suspension of the management, number one. All the responsibilities with respect to the compliances of that company is concerned still remain the responsibility of the suspended management. RP is to be helped by them to get all those things done. And as far as the administrator is concerned or RP is concerned, both are at the same footing as far as this insolvency is concerned.
Thank you so much, sir.
Good afternoon, ladies and gentlemen. I hope you all had a delightful lunch and are feeling refreshed for the second panel discussion of the day, which focuses on a critical aspect of insolvency ecosystem, unlocking value in distressed business, a valuer perspective. In today's discussion, we aim to address several key aspects, including regulatory updates and emerging trend in business valuation under the Insolvency and Bankruptcy Code, IBC. The evolving role of valuer in resolution and liquidation process, challenging in valuing a stressed asset with practical approaches and case studies, how technology, data analysis, and artificial intelligence are shaping the future of valuation practices, bridging the gap between the insolvency professionals and registered valuers for enhanced collaboration. To explore these topics, we are honored to have an eminent panel of experts and leaders and thoughtful influencers who bring a wealth of experience and diverse perspective. It is my privilege to invite our eminent panelists to the dais. Shri Rajesh Sharma, Honorable Member, former member, NCLT. A big round of applause, please. I would like to request Mr. Jatin Singhal to please come on the dais and present the planter to Shri Rajesh Sharma, sir, Honorable former member, NCLT. Members, Shri Rajesh Sharma, sir. He is a former honorable member, NCLT. During 3 years period, more than 2,500 cases were disposed of through detailed judgment by his divisional bench over a period of 500 days, sitting with an average of 5 cases disposed of on daily basis from out of 50 members listed per day for hearing. This is incredible. His judicial expertise and hand-on experience in insolvency case make his perspective invaluable for understanding valuation challenges.
Thank you, Abhinav. And back to the session, the valuer's perspective, unlocking value in distressed businesses. Today, there is a buzzword that we wish to take over the distressed businesses, and the valuation and IBC processes are becoming more and more important, which businesses to take up, unlocking the value and finding out the new good company through either IBC, NCLT route, and there also the valuation becomes very important. So let us hear from the eminent panelist about what is their take, how a decision making is to be done as a company secretary and IP and valuers. So I request Shri Rajesh Sharma ji, honorable former member NCLT, chair of this panel, to please take over the session.
Good afternoon, ladies and gentlemen. First of all, post-lunch session, we all can very well understand then how it is going to go about. If somebody is feeling sleepy, so please awake and try to, take few things which may be of your interest. You all are professionals sitting here, and I don't think any speaker or a teacher or a professional can tell you what you know more than that. On the dais, I just saw that there is a Pandey square and there is a Rajesh square. Am I right? So I hope in your evaluations also, you start squaring the figures instead of giving valuations. Why I am saying so? You see, valuation is always called as a science, and please underline this and, I'll dwell upon it later. Valuation is called as science and art, or art and science. You see, during my experience on the bench and otherwise also, I had to come across more than 500 valuation reports during the course of resolution process and so on. In IBI regulations, you need to, the RP has to have valuation from two valuers. And both are expected to be doing the valuation process independently. Now in lighter vein, I hope you will not mind it when I say something about valuation. During COVID period, when we were sitting in the bench, we came across a situation where two valuation reports were with us, and with a minor difference of value, which could easily be found out that, there has been some exchange of notes between the two valuers. We tried to probe the things, when did you visit the site, when all those things. So we came to know that the visit was also made by both the valuers on the same day. And the most beauteous part is, it was not written, but we came to know from our own resources that both of them went in a same car. I do not want to make any aspirations on the profession. Profession is profession, and we individuals make the profession. So, you see, both of them went in the same car, of course, because of COVID, cost, effectiveness, and all those things. See, the point which I'm trying to raise here is, the most important part of the valuation is the independence of valuers. And both are to be doing the job with independence of their mind and independent of each other. Now, when we say art and when we say science valuation, there is underlying word and if we speak in Hindi, ये साइंस और आर्ट है, और इंग्लिश वाला नहीं है, हिंदी वाला और है, इंग्लिश में एंड ही है. Many valuers tend to go strictly by the science part of the valuation, which is calculating doing the valuation strictly as per the book. That is science, purely science. No input of art. And many a times we see valuers who are doing it purely on artistically basis. When I say science and art, you know, the judgment to be incorporated by the valuer in his valuation report is both the things put together. Take an example of a EPC contract where an EPC company has come into insolvency. Now, you won't find many of the assets in physical form available with the EPC contractor, because the intrinsic value with the EPC contractor is the contract. And if that contract continues, the valuation is different, and if that contract goes away, the valuation is entirely different in this case. You go with fair value, you go with liquidation value. A simple request from my side to all valuers is that when you are doing a valuation of a distressed asset, you are sufficiently given the given the liberty to do the liquidation value as well as fair value. While calculating the fair value and while calculating the liquidation value, the intrinsic value of the assets of the company as a going concern or as a closed concern are to be taken care of. And can you believe, I'll give you one example. I won't name the case because, you know, the case is still going on. It has not completed. Otherwise, I would have shared the name also. While we were sitting in Mumbai, there was a big defense-related company. Name I will not give. When the resolution plan came to us, they were quoting the price of the resolution applicant. It was an ARC. The COC brought the resolution plan, RP brought the resolution plan duly approved by COC for about 650 crore. When we looked at the assets of the company and the strategic defense orders it was having in hand, we somehow were not comfortable with the resolution plan. Although throughout the from Supreme Court, NCLAT, NCLT, everywhere it is said that NCLT is not having the power of getting into commercial wisdom of the COC. But it was not issue of purely commercial wisdom. There were few other things involved in that, and we referred it back to the COC with our observations for rebidding. They rebid it, and can you believe what was the value fetched after rebidding? 5,950 crores. Now you can well understand that what type of acumen was required by the valuers for doing the valuation, because you know, as far as COC is concerned, if it is above the liquidation value, above the fair value, they'll accept it. But see the difference, it is more than 10 times. So the responsibility, although it is, you see, IBBI is always, behind the, basically against the RPs. All disciplinary proceedings are against RP, but not much against valuers. I don't want to say that everybody is into same field. In any profession, you will find some people who are very fair to their job, some people who are not that fair to their job. Oh, you see, but as a profession, when somebody talks as a profession, then he takes a wholesome view that, what type of people we are and what type of working we are doing. So with this, I'll just end here. And we have two practitioners, Mr. Dhamija and Mr. Mittal, who are deep into it. They will give you insight about what is presently going on and what is forthcoming with effect from 31st January. 31st January we are changing? That 31st January we are taking? Yes. So it will be a beautiful presentation. Just hear that. Thank you very much.
Really, sir, you set the tone for this discussion on this topic, valuation of distressed asset. And this is one of the challenging topic for every professional, because as rightly said by the sir, it is art or science. Very difficult to judge whether it is art or science. So it is a subjective matter, and it depends up to the valuer, depending on the circumstances beforehand, and whatever asset available before them to value it, and accordingly they move further.
There is an announcement. You see, we have discussed among ourselves. We will try to finish these presentations and speeches as early as possible, and we will give big room for questions. Okay, I think that goes okay with you. And we will try to answer them as far as possible.
Certainly, sir.
कृष्ण भगवान ने कर्मण्यवादी का रास्ते को उतना ज़्यादा इम्पोर्टेंस नहीं दी होगी जितने आईबीसी फ्रेमवर्क में और जुडिशियल प्रोनाउंसमेंट्स में कमर्शियल विजडम ऑफ क्रेडिटर्स को इम्पोर्टेंस दी हुई.
As per the panel chair, the forum is open for the question answers. We will take all your questions, and I'll request all the panelists to please answer your questions. Yes. If there are no questions, I have many questions. I will start asking the questions. Yeah. Please take the mic.
You are free to ask any question with respect to the subject matter of this, whether it was legal session or
Yes, sir. Sir, my question is there. Ki suppose the Khandelwal sir was saying कि RP was not have filed the section 60 subsection 5 applications day by day they are filing, so the volume of work have increased. But when we will go for the bank to release the lien on the on our funds, the bank are not releasing the lien. When we will go to the police to take the complaint, when the CD is giving the threaten to us, they are not registered the complaint. So what will do the IP in these conditions? So if they have not take the order from the court, so how the IP should proceed?
Continue doing what you are doing now.
Thank you, sir. Sir. Okay.
Hi, Rajesh on this side. One side I was just on a lighter side. Rajesh Sharma ji, Rajesh Mittal, Rajiv Pandey. So 3 RRR are there. so RRR, 3 R is there. So RRR.
One more question also.
Let me first complete the question. So it is like this one company which is a subsidiary company of a listed company. limited company, 3 directors were there. Because it was a material subsidiary company, one independent director from the material subsidiary company of the listed entity. So from the listed entity, one independent director was appointed on the board of that company. That company has gone into IBC. And only 3 directors were there. That gentleman who was independent director, he has completed his tenure in the parent company. And recently there was AGM, so that IP wanted him to continue. He said, how come I can continue, because I have already completed 10 years. But nobody else is also ready to join in because it's already in IBC. So company, although limited company, left out with only 2 directors. Even the second director who was retiring by rotation, and IP asked him to give his consent to continue as a director, he was also reluctant. So in that kind of situation, you know, how the board is going to work? Board effectively left out only with 1 director.
See, the answer is in your question itself. Answer is in your question itself. You said this holding company appointed an independent director in the subsidiary company. When the promoter is appointing or the holding company is appointing, where is the question of independence of the director? He is a director appointed by the promoter. He cannot be independent director. Yeah.
Independent director, see, as per the LODR, one independent director is required if it is a material subsidiary company. Pursuant to that, he was appointed, not by the promoter. So he was independent director on the subsidiary company.
Okay. Now the question comes is that how the company will run when there is no director. This is what your question is?
I'm saying out of 3, independent directors gone. It's a limited company. Left out with 2 directors. Other director is also not reluctant, is reluctant to give.
No, it depends upon the date of origination, date of CIRP, and all those things will come in play. You need to look at the documentation, and if needed, go to the NCLT for direction. But date of CIRP and date of his resignation, these are crucial things.
Not resignation, it's cessation after 10 years completion.
Cessation is which date? It is before CIRP or after CIRP?
Suspended board है ना वो तो.
After CIRP, even if it is suspended board, you need to take approval of NCLT for appointment of new director.
They can't appoint an independent director.
No, they can't appoint independent director, but you need to ask the order from NCLT that whether do we relieve him or not. That's
10 years completed, he has gone. Question of his relieving doesn't arise. Question of his relieving doesn't arise.
no. You need to look at the documents first. I can't answer like this.
Sir, ऐसा है राजेश जी, point here is that say board is already suspended and committee of creditor has taken over. A responsibility of that particular board lies with the whatever compliance requirement is there. That compliance requirement lies with the suspended board only. If say 2 members of the board are running the show, then definitely there will be non-compliance of say having minimum number of directorship. That's it. Beyond that, nothing is going to happen. So if at all there is a non-compliance, that waiver can be say taken from the NCLT at that point of time when you will be submitting the resolution plan. So that is not the issue at all. Problem is that whether COC or say resolution professional is able to run the resolution process or not. That is the main thing. If that is running fine, any direction can be taken from NCLT for waiver of the non-compliance done during the CIRP process.
And that will continue irrespective of whether there is a director or not, or a non-compliance is there. That can be once you will put somebody will be putting resolution plan. He'll also ask one waiver on this also.
So my question is limited to the valuation. There is a case which I am handling. There is a company whose valuation was done under Regulation 35. 2 valuers appointed. Valuer gave the average value of 70 crores. COC was not impressed by the valuation. So they conducted a third valuation. A third valuation was conducted which gave a valuation of 110 crores. Now the question arises, what shall be the valuation to be considered? Because regulation 35 says 2 closest of the valuation has to be taken. If I use regulation 35, I will be coming back to 70 crores. Then I will have to forego at least 40 crores. That's more than half of the previous valuation. So what should we do in that case? And another valuation appointment is not there in the provision of the code. So that's a point. What shall be done? Because already two valuer have given their opinion, which comes to 70 crores. Third valuation give a totally different. It is a 110 crores. It's a live case. It is before the NCLT. We are thinking to file it, but we are understanding how to go ahead. Because existing regulation doesn't allow me to go for fourth valuation. If I go for the fourth valuation, then how will it be computed? So please guide us for that.
But why you want to go for the fourth valuation? You have already 3 valuation reports.
But regulation 35, sir, says 2 closest has to be taken. The 2 closest are coming to the 70 crores. 2 closest are the 70 crores. And the third one gave me totally different value of 110 crores, which is COC is impressed. COC is saying we have to go by the third one, but regulation doesn't support us.
Have you brought this thing to the notice of COC, third evaluation?
COC only,
What COC says?
COC is supporting third one.
Commercial wisdom is supreme.
But
Ask them, what is the commercial
actually,
wisdom have?
they are supporting 110, but the regulation doesn't support them.
So then you can put it before COC and take orders from them that we are going to NCLT on this. No, of course, adjudicating authority will have to answer it. Of course, the answer will finally come from adjudicating authority only, but let them apply their commercial wisdom, then let them say that 110 is required, and once they resolve it, then take the approval of NCLT.
So we have to move to NCLT, sir.
And CLAT, NCLT.
NCLT.
Yeah.
Thank you, sir.
You see, all bucks are stopping in NCLT. Don't worry about it. Whatever you can't do, go to NCLT.
Just want to add whatever sir has suggested. Actually, as a resolution professional, it is our duty. In fact, whenever valuation reports are coming, it is not only that you will just put the say mathematical value to the table of the COC. I think you need to do the analysis of the whole report, all three, why this kind of difference are coming, put forth these differences before in front of the committee of creditor, and then let committee of creditors has to decide that what is say there in the each valuation report which is bringing the so different reports and so much of the difference in the valuation. If at all you are not able to say resolve those differences and you are finding that valuation report itself is defective, then you can go and as say sir has suggested, you can always go and approach NCLT and seek direction for the conducting the whole valuation process afresh. You don't appoint for 1, 2, 3. You go afresh and ask for the fresh valuation from the say different set of valuers altogether. So that direction NCLT can always give.
You see, I'll give you a live example. I won't name the case, but yes, when we were sitting in Mumbai, another branch of NCLT, there was a difference of opinion between two members about the valuation of the, because two valuations came, both the valuations, it was found that these are on lower side. Then one of the member dissented and said that third valuation is to be done because seems to be a basic difference. The third judge was appointed and she ordered for another valuation. Now, what happened in all this process, about 3 years' time was spent. Now, 3 years back, some valuation was there. After 3 years, same valuation may or may not be there. Okay. So, what has happened is that the operation is successful, but the patient is dead.
Valuation is just a benchmark. So it is only a negotiation card that yes, this is the valuation, what is the resolution applicant offering. So COC can always put this card of 110 crore in their pockets, and while during negotiations they can say, look, this is the value of the company or the corporate debtor, and you have to reach to it, because while liquidation valuation are not disclosed to a resolution applicant, and disclosing this to NCLT is again something which you are making it open to the domains and all. So it is a trump card for the COC to put in pockets and take it during the...
Abide by the regulations of IBBI, otherwise DC will be on his head.
No. So he is following. They may follow.
I interrupt here. You know, I am going to read out the regulation 35, which talks about the third valuer. We have already discussed if the difference is more than 25% and above, there is a or COC can appoint valuer. I mean, if they give the recommendation. Below that, when you have a two valuer, third valuer also, they have given the report. They said after that, paragraph says the average of the two closest. Now you have to look into that. The average of the two closest estimate of the value shall be the value under this, valuation rules. So 1, 2, 3, okay. Then closest of the two. I mean, then you have to look into the facts and figures of the individual case, which is closest. Even again the ambiguity is there. What means closest? But you have to apply your, judgment and knowledge.
Thank you, sir. Thank you.
Good evening, sir. It has been a very interesting and knowledgeful session, and thank you for that. My question is in respect of operational creditors. So what remedy do they have, because as per waterfall mechanism, they are left with very, very limited rights. And even if they go to NCLT, I think maybe near to 1% of their dues are admitted and dispersed. So what is the remedy for them?
You see, as far as operational creditor is concerned, he is king till the time the case is not admitted. Once the case is admitted, he is a beggar. His interest is that the case should not be admitted and let it be lingered on as far as possible. Only then he will recover something.
So now
I have something to put up. So it's not a query basically. So we have been discussing about valuations. So basically 3 classes and all. So we see there is a lot of lacuna in awareness with respect to intellectual properties. Because now when we see India for the past decade, intellectual property in India is much valuable. All the international companies are setting up their IT companies in India. And of course, IT companies are not in distressed assets, but sooner or later we may face this situation. So I believe like you all are panel members and of course privileged members. So there should be one specific class on intellectual property which may cover goodwill also, because goodwill, we are fitting somewhere in between these 3 classes, but it can fall under intellectual property, the enterprise value, or the patents, because Indian medical setup is so much integrated and it is doing so good. IT infrastructure, IT softwares, applications, Bangalore is a hub, Hyderabad is a hub. So, and few companies are falling. For example, Baiju, of course, it's an edtech platform. We never know what the next 10 years take us. So there should be specific sessions on intellectual property valuations. Everyone, you all might be knowing, but not a common professional might be knowing that how to do this. So this is just a feedback from me. Yeah.
Yes,
it's
I
not
think
a question,
the management
yes.
of the IIP can take, it's a good suggestion.
Yes.
You referred the case of Baiju, and Baiju, from which place to which place its valuation have come down, irrespective of IPRs.
Yeah.
Have you seen the fluctuations in the valuation of Baiju?
Sir, I have worked for 3 months in Baiju, so I know everything.
Yeah. What did you say?
I worked in Baiju, so I know
So
that.
from where and which place to?
IP point of view. From IRP point, RP point of view. Not now anymore. So I'm open to tell. Yeah.
In the morning session, you asked some question about the ballooning of.
Definitely, that is with respect to
You see,
financial.
I'll give you one example. It is a live case which was before me at one point in time. Technology Development Board, TDB, had filed a petition, Section 7 petition, against a company for 1600 crore rupees recovery. 1600 crore rupees debt. We asked them at what time, we asked them, how much money did you lend them? They said 8 crore rupees. 8 करोड़ रुपए डिस्बर्समेंट करी थी 1996 में, जो बढ़ बढ़ के 2019-20 में 1600 करोड़ रुपए हो चुके थे. तो from the bench itself I asked a question from him. I said, you are from Technology Development Board? He said, yes, but we have taken over this loan on assignment basis from SIDBI. I said, show us your ledger account where this 1600 crore figure has come. They said, we have taken it over in 2012. After that we have ledger account, but before that we don't have ledger account. But I asked them, are you sure rupees 8 crore were disbursed by you? Yes. In which year? 1996. So I said, are you compounding it on annual basis, quarterly basis, monthly basis, daily basis, hourly basis, minute basis, or second basis? Tell me, how are you compounding it? He had no answer.
So with this thing,
just to answer, just one second, just to answer your question about, you asked a question about the programs or intangible valuations. I think ICSI and ICSI RVO's teams are here, and regularly these kind of programs are conducted, which also cover the valuation of intangibles. So you can attend one of them.
You have the recordings are available on YouTube channel of RegisteredValuers.
Sir, it is not about attending. Someone who is interested, they will attend. We are not required. Awareness is most important. It should be readily available for anyone to access. Just like IBBI is a platform wherein you can see everything. So it is just.
That is all available on the YouTube channel of ICSI. That is available free of cost. Anyone and everyone can go and watch any of the sessions which are available there.
Sir, my suggestion is let us have one more different class. My suggestion is that.
Okay.
Let us have a different class. So that makes more transparency rather than the IP thinking what he should do, whom he should approach, whether there is any pan.
Yeah, you have touched a very good question. You know, when we talk about a service industry or IT industry, 80% of the value is coming from intangible only. But the challenge is there is the accounting standard which prohibits that the in-house generated IPRs and other things cannot be capitalized. You will not find the brand value of a Hindustan Times in their balance sheet. You know, this is a self-generated assets and intangible assets. Now the challenge comes, how the company has gone into ICSI, then the value of definitely the intangible assets will go down. You know, there is one beautiful case, I will refer that, ICSI Bank versus Unimark Remedies. You know, here, it's a running company, it went into difficulties only.
I was quoting Unimark Remedies only.
Yes, in this case, what happened, you know, very interesting case, they got a notice from the US FDI. They said there is a non-compliance, only they have issued a warning notice. The valuer has considered it as a zero rate. Even then NCLT said, by giving a warning letter, the export only in one country is going to be affected and not the other 16 or 17. So in that case, you know, when you talk about the intangible assets, definitely the input from the promoters. When I was just discussing in the panel, you know, the vendor code has a value because, you know, the company has taken a vendor code from auto sector. It's very difficult to get the new vendor code. In this case, the vendor code was valued. It was insisted, and in the judgment, I have been told that in the judgment it said that the vendor code will also be transferred. You know, such a intangible, powerful, because, you know, it is difficult to get a vendor code.
Sir, I would say reality,
Yes.
even patents, I would say reality, even patents are not valued for many companies.
Yes.
So,
Yeah, it is.
please,
tangible assets means tangible and intangible.
Sir, due to paucity of time, our panelists have so many things to express, and the topic it is IVC as well as the valuation. So we can sit here and discuss so long, but we are. It is. If anybody from else this side, kindly give the mic to this side. वहाँ दो. Great, great, sir.
You see, what we thought of, Nisarji, what we thought of, that you see, everybody is an educated and, well understood people. They know the law, they know. Better would be that whatever is coming in their mind, that should come out. You know, nobody is interested in having a lecture. You can see YouTube, you can.
Designing this program.
Yes, yes.
I was really scared of that valuation. में क्या लोग सुने?
So we thought. So
I'm very happy, sir.
our panel thought that let us ask questions. Let them allow whatever questions they have in them.
Yeah. So I just want confirmation of my understanding that objectively subjective means criterion for valuation may be subjective, but it is objectively reasoned.
Yes, it's the observation.
You see,
Mittal sir, give the proper answer of this.
in valuation, you cannot act without being subjective, but you have to be objective enough, and your subjectiveness has to be properly documented. Am I right in saying that?
Absolutely. This is what it means. So you had to apply your judgment as a valuer on multiple situations, multiple counts. But how do you apply your judgment? So the moment you apply judgment, then you are subjective. That subjectivity should be applied within the four walls of principles of valuation standard, properly documented, communicated through the valuation report. That's what it means about objectively subjective.
So it should be objectively reasoned, you mean to say.
Sorry.
Thank you.
Objectively reasoned, yes.
Yeah.
Right.
Yeah, that's right.
Thank you, sir. Thank you, sir.
So any other question from the audience side? So it is, no. So with this thing, and thanks to our program director for organizing such a nice program and very successful program, because every speakers are present here with the blessing of Nisal sir, and he has coordinated nicely since the morning of the starting of the program and till now. So it shows the efforts of all seniors, and thanks to everybody who has joined the program in this number. Thanks to our panelists, renowned panelists, and a special thanks to our chair, Rajesh sir. And so many things we have deliberated, discussed, but thing is that again, IBC, Insolvency Professional and Registered Valuer, both are not different. Both are synonymous to each other. And whatever report given by the valuer, that is going to be relied by Insolvency Professional. So with this thing, thanks to everyone. Over to.
Thank you. Thank you to all the esteemed panelists for their insightful and thought-provoking contribution. This session has provided us with the comprehensive understanding of valuation, critical role in resolving distressed business, offering valuable perspective on challenges and opportunities in the field. Thank you very much. So, as a token of our appreciation, we will be presenting memento to our panelists and panel chair. These tokens symbolizes our heartfelt gratitude for their time, expertise, and valuable contribution to today's discussion. For this, I request Nisar Ahmed sir to please come on the dais and present memento to Rajesh Sharma sir. I request the audience to give a big round of applause, please.